Good morning, my fellow friends and Madam Shahila. Today, my teammates and I are here to present about thought. The subtopic given is negligence and vicarious liability. Before I enter into this topic,
introducing my group members: Muhammad Zuhaidi bin Tajuddin, Nurdiana binti Daniel, me myself Janani Apasami, Prashantini Muniandi, and Nur Fadlin Sakina binti Muhammad Saleh.
let me briefly explain about what is thought. A thought is an act or omission that gives rise to injury or harm to another and amounts to civil wrong for which courts impose liability. Now, Zul Haidi will start his presentation by explaining what is negligence. Thank you.
Now I will talk about negligence. Negligence is a principle of tort of law that apply to casualty insurance in certain state. When an incident occurred, the fault or negligence of each party involved is based on their prospective contribution to the accident. This allows to assign blame and pay insurance claim accordingly. Negligence is the most important area of tort of law in the modern version of negligence, which is established in 1932 after case Donoghue vs. Stevenson. Negligence is defined in Winfield and Jolowish of tort as breach of legal duty. The duty that I means is a legal duty care, which is the result of damages undesired by the defendant to the plaintiff. The ingredient of negligence are a legal duty of the part of A towards B to exercise care in such support of A as fall within the scope of duty. The second is breach of the duty, and the last one is consequently damage to B. So this is the meaning of negligence. Based on article Law Office of Malone and Campolo, negligence is most commonly used to assign blame in auto accident. If two drivers both break the same traffic law in an accident, then both may be denied their claims. Many insurance carriers assign blame between drivers on a percentage 17-10. If two parties are involved in car accident, the insurer use comparative negligence to assign fault. Determining fault in accident is a critical aspect of insurance. Insurance companies litigate to ensure that they are only liable for damages caused by the insurance client. In addition, defense lawyer will attempt to limit responsibility to the smallest extent possible. Reviewing action that lead to an accident, insurer and the court determine how to assign the fault. That process is the essence of comparative negligence. The determination of law will unlimitedly lead to deciding how much the insurer must pay. We'll talk about the negligence case between Donoghue and Stevenson. This is one of the famous cases in English law. In 28 August 1928, Mr. Donoghue friends brought her gingerbread from Well-Me-Done Cafe. She consumed about half a bottle and was made of dark opaque glass. When the remainder of the contents was poured into a tumbler, at this point, the decomposed remains of a smell floating out, causing a allergic shock and severe gastritis. So, Mr. Donoghue was not able to claim through breach of warranty of a contract because she was not a party to any contract. Therefore, she is proceeding against the Stevenson, which is the manufacturer, and the issue come up with the House of Law, which is their court. And the question of the House of Law was if the manufacturer owed Mr. Donoghue a duty of care in the absence of contractual relations contrary of established law case. Donoju was effectively a test case to determine if she had a cause of action, not if she was owed compensation of any damages suffered. So the court said, although there are contractual duty on the part of manufacturer, offends the manufacturer towards her duty to care that the bottle did not contain the matter, and she would be able if the duty was proved. Thus, plaintiff was entitled to recover damages against the manufacturer negligence. So I will pass to Diana to continue the topic of negligence, which is duty care. Thank you.
A duty of care is a legal obligation imposed on an individual in tort law that requires adherence to a reasonable standard of care while performing any acts that could foreseeably harm others. It is the first element that must be established before proceeding with a negligence action. The claimant must be able to demonstrate that the defendant violated a legal duty of care. Individuals may be held liable if they breach a duty. The duty of care may be imposed by operation of law between individuals who do not have a current direct relationship but who become related in some way in the future as defined by common law. In determining whether a defendant owes a duty of care to a plaintiff in a given case, the facts and circumstances of that case must be considered. However, for this principle to apply, the plaintiff does not have to be identifiable by the defendant. It is sufficient if the plaintiff is a member of a class within the area of foreseeable injury. The existence of a duty of care for personal injury and property damage was originally decided by Lord Atkins' Neighbour test from Donahue versus Stevenson. This case established the neighbour principle to establish a duty of care. A defendant owes a duty of care to their neighbours. A neighbour is someone so closely and directly affected by my act that I ought reasonably to have them in my contemplation as being affected when I am directing my mind to the acts or omission in question. Lord Atkins said that the rule that you are to love your neighbour becomes in law. You must not injure your neighbour. And the lawyer's question, who is my neighbour, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. The case Haley versus London Electricity Board 1965 is about the defendant's employees dug a hole in a pavement. When they left the area on their break, they realized that they had not been provided with the necessary materials to fence off the area. They thought it would be sufficient to leave an upright shovel near the hole as a warning to any pedestrians who passed through. The claimant, however, was blind and so did not see the warning. As a result, he fell into the pit and sustained injuries. Establishing the tort of negligence involves establishing that the defendant owed the claimant a duty of care, which they breached in a manner which caused the claimant recoverable harm. To establish a breach of any duty owed, the claimant must establish that the defendant failed to act as a reasonable person would in their position. The issue was whether the defendant was in breach of their duty, given that they argued that they had taken sufficient steps to enable normally sighted people to be safe. They argued that it was not foreseeable that blind person would enter the area without assistance. The defendant was held to be in breach of their duty of care. The extent to which the harm was a foreseeable consequence of the defendant's actions was indeed a crucial factor when determining how a reasonable person would behave in the circumstances. However, the court was not convinced that it was unforeseeable that a blind person would walk down the street. If it was sufficiently foreseeable that a disabled person would be at risk of harm, the court held the defendant was obliged to take reasonable steps to protect them from harm, not just able-bodied persons. Another case that related to the duty of care is a David Top versus London Country Bus Southwest Limited 1193. The defendant, a bus company, left an unlocked bus with the keys in the ignition in a lay-by overnight, as it was expected to be picked up on shift by a driver of the company. However, this driver did not show up for his shift, which led to a group of thieves stealing the bus and driving it away. Sadly, they knocked a woman off of her bicycle, which led to her death, which caused her husband to sue the defendant bus company. He claimed that the bus company owed a duty of care to his deceased wife. The courts held that the bus company did not owe a duty of care for the acts of the thieves, as they were a third party. It was not foreseeable for the company to anticipate this happening, so it was not their legal responsibility to protect and guard against the fact that thieves stole the bus and ran his wife off her bicycle. Why this case is important? This case is important to the law of negligence because it establishes the key principle that there will be no duty of care if there is no foreseeability. In this instance, this referred to the bus company's duty of care over third parties. This is not regarded as a harsh decision due to the facts of the case. As much as there had been a tragic death, there was no evidence to state that it was the bus company's responsibility to guard against such third parties possibly causing such an act.
Assalamualaikum and hi, my name is Norfadin Sakina binti Muhammad Saleh. Today, I want to talk about breach of duty. Breach of duty. A breach occurs when the defendant fails to meet the minimum standard of care required of him or her, and the minimum standard of care is that of a reasonable man. Reasonable man is an objective standard that disregards the defendant's state of mind. At the same time, he committed his negligence act. As a result, the question is whether a reasonable man in the same circumstances as the defendant would have acted the same way. If the answer is no, the defendant has breached the duty of care. Cases related to breach of duty is Bohin vs. Young 1942. Facts. As a result of negligent driving, the motorcyclist collided with the car and died in the accident. The plaintiff was 45 feet away from the scene of the collision when the accident occurred. Despite not seeing the accident, the sound of the collision occurred severe nervous shock. As a result, she was unable to continue her business. Help. The motorcyclist owed a duty to other people on the public driveway not to cause them any harm, including the plaintiff's injury. However, because the plaintiff was not in the area where the defendant's careless driving posed potential risk at the time of the accident, the defendant owed no duty of care to her and was not found negligent in relation to the plaintiff. Another case related to breach of duty is Bolam vs. Friend Hospital Management Committee 1957. Facts. The plaintiff was undergoing electroconvulsive therapy as treatment for his mental illness. The doctor did not give any relaxant drug and the plaintiff suffered a serious fracture. There was divided opinion among professionals as to whether relaxant drugs should be given. If they are given, there is a very small risk of death. If they are not given, there is a small risk of fractures. The plaintiff argued that the doctor was in a breach of duty by not using a relaxant drug. Held. The High Court held in favor of the defendant. The doctor were not in breach of their duty because responsible body of medical professionals agreed with their practice. This is a journal clipping from the case of Bolam vs. Friend Hospital Management Committee 1957. Magnitude of the risk. When deciding to act in a certain way and determining the standard of care required, a reasonable person will consider the potential risk. It is necessary to consider the magnitude of the risk. This entails considering the likelihood that the defendant's conduct will cause damage or injury, as well as the severity of that damage or injury. Cases related to magnitude of the risk is Bolton vs. Stern 1951. Facts. The plaintiff was injured when a ball from a nearby cricket pitch struck her outside her home. The cricket field was designed with a 17-foot gap between the ground and the top of the surrounding fence. Balls has been known to bounce over the fence and land in people's yards, but this was unusual, making the strike that struck the plaintiff exceptional. The plaintiff sued that the cricket club in the tort of negligence for her injuries. In this case, the likelihood of the harm was very low, and a rating offence any higher than the defendant had already done would be impractical. The cricket club was also providing a social useful service to the community. A reasonable cricket club would have therefore not behaved any differently. Another case related to magnitude of the risk is Miller vs. Jackson 1977. Facts: the defendant had played cricket on a particular area of land for around 70 years. The plaintiff bought one of the houses and then complained of the negligence and nuisance from the cricket balls landing off the property. The plaintiff suffered damage to the property and also complained that the activity of the cricketers prevent the enjoyment of their land and causes of damage. The defendants were found guilty of nuisance as well as negligence by the court. However, the injunction was lifted because the court determined that the public interest was a crucial factor to consider. The public interest in preserving cricket on village greens outweighed the private interest of neighbours, so no injunction could be granted. This is a journal clipping from the case of Miller vs. Jackson, 1977.
Good morning, madam. My name is Prashantini Munian. I would like to explain about remoteness of damage. Remoteness of damage relates to the requirement that the damage must be of a foreseeable type. In negligence claims, once the plaintiff has established that the defendant owes them a duty of care and is in breach of that duty which has caused damage, they must also demonstrate that the damage was not too remote. This principle was reflected in the case of Barnett vs. Chelsea and Kingston Hospital Management Committee. Mr. Barnett went to hospital complaining of severe stomach pains and vomiting. He was seen by a nurse who telephoned the doctor on duty. The doctor told her to send him home and contact his doctor in the morning. Mr. Barnett died few hours later from arsenic poisoning. Had the doctor examined Mr. Barnett at the time, there would have been nothing the doctor could have done to save him. The hospital was not liable as the doctor's failure to examine the patient did not cause his death. However, the doctor was guilty of a breach of his duty of care. Therefore, the plaintiff's claim was failed. The last part of negligence is contributory of negligence. This is defined as where the plaintiff's injury have been caused partly by the negligence of the defendant and also contributing his own negligence. In these circumstances, the plaintiff cannot recover anything. As an example for the explanation, in a motorcycle accident between motorcycle A and motorcycle B, motorcycle A's biker was speeding and motorcycle B's biker was riding drunk. Both bikers are engaged in negligent risk, creating behavior. The negligence on the part of the injured plaintiff is called contributory negligence. The rule is harsh and privation is occurred, particularly the plaintiff's negligence was not a prime cause of the accident. That's all from me. Thank you.
Thank you, Prashantini. I am going to talk about vicarious liability. What is vicarious liability? Vicarious liability is a situation in which one party is held partly responsible for the unlawful actions of a third party. The third party also carries their own share of the liability. This is the legal framework at play when you are sued over mistakes made by your contractors, employees, or agents. We should know all the requirements of vicarious liability should be established first in order to claim under the tort of vicarious liability. The requirements are as following.
Firstly, there must be a wrongful tortious act such as assault, battery, false imprisonment, conversion, intentional infliction of emotional distress, fraud, trespass, and so on. Secondly, there must be a special relationship between employee and employer. Thirdly, the tort must occur within the course of employment. Besides that, a contract of service must satisfy three conditions. Let's look at the three conditions. The employee agrees that in consideration of wage or other remuneration, he will provide his own work and skill in the performance of some service for his employer. Meaning to say that an employee concurs that he or she will work for his employer because he is getting compensation, and he or she agrees expressly or impliedly that in performance of that service, he will subject to others' control in sufficient degree to make that other employer, the other provision of the contract are consistent with its being a contract of service. There are many decided cases on vicarious liability. I am going to narrate two cases. The first one would be Cassidy versus the Minister, decided in 1951, is an English tort law. The fact of this case is the claimant was a patient at the defendant's hospital who needed a standard therapy to realign the bones in the wrist. The operation caused his fingers to become stiff due to one of the doctor's negligence. On the basis of vicarious culpability, the claimant sued the defendant in tort of negligence. The Court of Appeal held that there was a negligence by the hospital's employees in the course of carrying out their duties. The hospital was therefore vicariously liable for their actions. Another decided case that I encountered is Matthew vs. Barlow, decided in year 2003. In this case, the claimant, a self-employed carpenter aged 40, was stabbed by a doorman employed by a nightclub called Flamingos. His spinal cord was severed and the claimant was left paraplegic. Cranston, the doorman, was charged with grievous bodily harm and sentenced to 8 years imprisonment. The claimant subsequently brought a claim for personal injuries against the employer Flamingos, owned by Mr. Pallock. He alleged that employer was vicariously liable for the doorman's action. The court held that the club had vicarious liability for his act. There was a sufficient connection as to time, location, and nature of his acts to create liability. These are the two cases that I encountered on vicarious liability. Finally, I came across an article in New Straits Times on 21st July 2020 at 12:30 a.m. In this article, Dr. Ashka Ali Muhammad asserts that the workplace should be free from sexual harassment, such as degrading words of pictures like graffiti, photos, or posters, physical contact of any kind, and sexual demands. When an employee or customer sexually harasses a co-customer or customer, the victim may file a vicarious liability suit against the employer or government, provided that the act occurred during the course of employment. Litigation against the employer is founded on the basis of failure to use reasonable care to protect its workers against foreseeable sexual assault. In order to prove vicarious liability, for example, against the employer, the victim must prove that there was an employment relationship between the parties, which is one of the requirements of vicarious liability, as I said earlier or previously, and also that the conduct in question was in the course of employment.
In a nutshell, negligence law arises from the law of tort. In any negligence action, the essential ingredients that should be present are firstly, a duty of care exists wherein there must be a wrongful and unauthorized act or omission by the defendant, and secondly, the act or omission in question affected the interests or rights of others. Lastly, the act caused the injured party or victim to have a right to damages. Moreover, we can learn that negligence is the fundamental legal basis for a personal injury claim, and it plays an essential role in determining whether an injury victim will be able to receive compensation and how much compensation they may receive. It also provides the moral basis for an injury claim, demonstrating that the victim suffered because of the irresponsible conduct of the responsible party. As a conclusion for the vicarious liability, the intention behind the principle of vicarious liability is to provide compensation to the victim by the proper party who is accountable for the harm. Companies are made criminally liable for the offences committed by their employees within the scope of their employment. Further, certain key employees of the company are also made criminally liable for the offences of the company. Thank you.